My Lords, may I just deal with a couple of small points before I, so to speak, begin again? I found the paragraph in Cretu which confirms the residual well of optional cases, and it's 36 at page 923.
Thank you very much.
Of the bundle.
923. Which bundle would that be?
Of the authorities bundle, which Cretu is number 31. It starts at page 907, and the reference was paragraph 36 at page 923, and it's not even strictly true to say I found that reference, so I should make that admission. The second thing is the closest we've come after discussion to an Article 6 case where there is some danger is Jones against the United Kingdom, which is the one that started the reasonable foreseeability test.
Yes.
That, I'm afraid, is the best we can do on that one. And the other preliminary point I just wanted to mention was Article 6 only applying from the point of charge. I understand, of course, the wording of Article 6, but that very general statement from Mr. Fitzgerald needs to be treated with a little bit of caution, because, of course, there are cases that deal with, for instance, what happens in interview, pre-charge, where you're not represented.
Yes.
And those are caught by Article 6 when somebody is later charged. And I'm thinking of cases such as Ibrahim, which is in the bundle, which was a case against this country, but also Saldus against Turkey, Oyzer and the like. But it's
yes,
not...
I mean, charge is an autonomous concept here, is it not?
Yes. And I don't demur from what Mr. Fitzgerald generally says. Of course, Article 6 is worded as to the rights that are provided at the point of charge and thereafter, but it does, in fact, apply a bit more broadly. My Lords, with those preliminaries, can I go back to where I was, which was... again, dealing with this question of what point on the spectrum of knowledge somebody has to appear and what they have to know. And may I take up an expression which is used in Zagrean, or Zagreen, which you've already been taken to. It's at tab 32, page 928. And specifically at paragraph 85 at page 952. Because it provides a very useful, well, certainly a useful shorthand, but I would say a useful test more broadly. There were three cases that were dealt with simultaneously in the case of Zagrean, and the third one is dealt with very shortly at paragraph 85.
Page number, sorry?
952, my Lord.
952, thank you.
He, Mr. Chihaya, had admitted in evidence he'd had personal knowledge of the summons through his mother. And he was responsible for any ignorance on his part. But the point that I rely on is this. He left Romania at a time when he knew, or ought to have known, that a criminal investigation was ongoing, and without having made arrangements to receive any court process. Now, there was a time when what was known as KMOC, knowledge or the means of knowledge, had a particular resonance. It comes originally, I think, from the case of Kittel in the European Union, which is a case entirely to do with VAT. And it was at the time when VAT carousel frauds were the fashion, when goods were imported into this country, sold through a whole collection of intermediaries, and exported, and the person with liability to pay the VAT upon import vanished, and the person at the end of the chain who exported was entitled to claim VAT, and very large sums of money were made by means of those frauds. And the test that was used to refuse repayment of VAT was knowledge or means of knowledge that the entire chain was dishonest. That's a bit of an aside and probably entirely irrelevant, but I noted that the expression was picked up and used in Zagrean, and it will be my submission that knowledge or means of knowledge is a very useful shorthand for somebody who is deliberately absent in terms of Section 20, subsection 3. So,
how does that sit with the Spokovich case, 1199? The individual was shot, and the person immediately left and escaped and evaded justice. Presumably, if he shot him, he would have knowledge or means of knowledge, and he was going to be prosecuted.
With great respect, no. 1199, I think Sedjevic against Italy. There is a distinction drawn in all the authorities between those who, as I said, I think before the short adjournment, disappear before they are within the criminal justice system at all. Now, it may be that they disappear for reasons that indicate their guilt. It may be potentially that they might satisfy the fugitivity test. But to say that they disappeared because they shot somebody, first of all, is an inversion of the presumption of innocence. And secondly, there's very generally no evidence that that's necessarily, maybe a darkly held suspicion, but there's no evidence that that's necessarily correct. And it would not, in my submission, be sufficient to engage deliberate absence. If you disappear, and other cases, along with Sedjevic, are Bletter and Sibgatulian.
Could we have the references for those, please?
Bletter is not, for some reason, in the bundle, although it's quoted at length in various cases, including Bikiok. Sedjevic is 49, tab 49, 1183. Sibgatullin is tab 53 at 1285. And another one in that collection is T against Italy, which is at tab 47 at 1182. And the point about all of those is that they left the requesting state before they had been arrested, before they'd been accused, before they'd been contacted by the authorities. Now, it may well be the case that they left for the worst of all possible reasons, but the courts have found that it's not sufficient to say, you killed a man, so you must have known. That was the argument run by counsel in one of the cases. You killed a man, so you must have known the authorities would be after you and they'd want to try you. In those circumstances, insufficient. So you have to be, at the very least, in my submission, in the criminal justice system. And more than that, you have to be made aware that you personally are under investigation for specific conduct. I wouldn't necessarily say it has to be a specific offence, whether it's, for instance, in English terms, a Section 20 or a Section 18 grievous bodily harm or an attempted murder, doesn't matter. But you have to know that you are suspected of conduct that caused grave injury.
So it has to be part of a criminal process as opposed to the trial. Is that right?
Yes, you have to be within that process.
And so Cretu would therefore be incorrect.
Well, Cretu, no, because Cretu relies. Cretu, yeah, again, I don't wish to put a particular gloss on it, but Cretu is a case that deals with methods of proof above all and procedure. And if the requesting state ticks a relevant box, you don't need to go any further. You don't go behind that. So in the case of, as I say, Sibgatullin, he was accused of conduct in Uzbekistan, but he'd left for Russia before the finger of blame ever pointed at him. In the case of T, he was working in, well, I don't think the facts were clear, whether it was Kingdom of Saudi Arabia or Sudan, when he heard via his wife that his daughter had made an accusation against him. And that was held to be, quotes, vague and informal. He hadn't been contacted by the authorities. He certainly hadn't been stopped before he left to go and work abroad. All of those, and this echoes something I'm going to come to in a moment, which is Mr. Justice Higginbottom's, one of his subparagraphs. All of those people had in fact put themselves beyond the reach of the authorities, and in the terms of the case law, made it difficult or impossible for the authorities to reach them, but not necessarily for morally or legally blameworthy reasons. And I would accept that if you are not aware of any possibility of trial, or even that a finger of blame is pointed at you, then of course you can't have waived your rights, however much you may have run away.
Just coming back to the paragraph you showed us in Zagrean, paragraph 85.
Yes.
You refer and rely upon the observation that he knew about the criminal investigation. Perhaps you can help me. If one actually looks at the facts that are set out in the judgment relating to his case, which start at paragraph 26, the district judge ordered extradition upon the contents of the EAW, so far so straightforward. And then in paragraph 30, the court refers to a translation of a decision that came later, a decision of the criminal division that considered his case in his absence. And it quotes from the judge as saying, "The defendant was interviewed solely during pre-trial proceedings." Now, obviously the civilian systems are not even all the same, but it's not unusual for there to be a judicial process, in other words, criminal proceedings, during which people are interviewed formally, and then a trial, as we would understand it, follows.
Yes.
But there's a difference between the judicial proceedings, which it might be thought that's referring to, and the initial police investigation. And I just wonder whether you know what the answer is in respect of paragraph 30. It seems to me to be different from what we're concerned with, or at least very possibly.
I don't know on the facts what the position was, although I do note that in paragraph 85, his own admission, which was taken against him, was that he had personal knowledge of the summons through his mother.
Oh, yes,
I suppose that's a Dvorzecki point. But it is not this case. We are, well, arguably both in a stronger and a weaker position. It's not our evidence that Mr. Bertino was interviewed at all by anybody, although he says he was questioned.
Yes.
It is, however, our case that he signed a document which was explicitly for purpose of service of process. And so undoubtedly, using the test that I was adumbrating before, he was within the system. He was in the criminal justice process system. But I realise none of that is an answer to your Lordship's point as to exactly what the position was. Chow, I don't know if...
It's not in the case.
Well,
It's not in the case, yes.
There's the same observation I would make about paragraph 81 that Mr. Fitzgerald relied upon, that if you look back at the facts relating to Mr. Am I pronouncing it correctly?
Sunku, I think. Yes.
They're very complicated, very complicated indeed.
Yes.
Anyway, there we are.
I mean, this concept of being within the criminal justice system sounds a bit vague to me as a concept. It's a bit unclear, isn't it? What precisely you mean by that? I mean, the advantage of prosecution or charge is that it gives a degree of certainty to what time we're talking about.
Well, it may or may not. That would be my first answer. the reason that I'd highlighted in the case that here the entire process to the point of conviction is called an investigation merely illustrates the fact that one sometimes has to be very careful about terminology, and certainly in terms of equating it with what we have in this country. I mean, nobody in this country would be told at the point of charge, if you don't turn up and you breach bail, you're likely to be tried in absence. That is something that's not even done at the Magistrates' Court, it's done at the pre-trial review in the Crown Court. But sorry, I've lost my train of thought.
I'm just struggling with what precisely within the criminal justice system means.
Well, I recognise that it's an imprecise term. I recognise and I accept what is said in Bletter and followed in a number of cases, that Parliament, in drafting Section 20, used the word deliberate absence from trial. I recognise they could have said absented himself from legal process, which I think was originally said in Bletter. It's quoted with approval in Cretu and again in Bichiok. Now, that could be subject to different interpretations in different states. And in my submission, the reason trial was used is not only because it has an obvious resonance for the district judge who is making dozens of these decisions, but also because it's the Article 6 word. You have fair trial rights, you have rights at the hearing which decides your guilt, and those are the rights that ultimately are being protected by all of this. The rights that you have at a hearing convened to decide your guilt or innocence until or unless you waive them. And that brings you back in time to the point where you have decided that you are going to absent yourself. Now, I'm not wedded to the expression criminal process. What I was trying to distinguish between is somebody who has not been in contact with the authorities and has no knowledge, or has only informal and vague knowledge that he may be wanted, and for very good reason, or he may be wholly innocent and know nothing about it, and somebody who is at a much later stage. But if you set your cut-off only at the point of trial, it creates an enormous practical problem, because a lot of people, including Mr. Bertino, will know full well that they've been arrested about something, that the police instantly seized the only evidence which was required to establish their guilt of sending text messages, that they were required to turn up at a police station at the other end of Italy, they were required to sign, that they were told a notitia criminis had been issued in their name in relation specifically to the conduct, that they were required to provide an address for the service of legal process, which can only mean court documents, and they were required to
only mean court documents.
Right, that is my gloss. But legal process, in the context of a criminal notice,
It's for the service of documents within that process.
yes. At the very least, perhaps.
Service of any document executed by delivery to the defence lawyer, and then it goes on for the purpose of service of process.
Yes, perhaps I should have said not can only mean that. You're quite right to catch me out. But for all process, all court documents, which is going to include a writ of summons and notification of trial, and the final point is he was required to identify at that point whether he wanted his own lawyer or a court-appointed lawyer, and he was told that if he failed to comply with his obligations as to address, everything would go to his lawyer, and he chose the court-appointed lawyer. So he certainly doesn't know the date and time of trial at that point. But he certainly does know that he is accused and has obligations to comply with the requirements of the authorities, and that there will be consequences if he doesn't. So that's why, as perhaps a shorthand, I said he knows he's within the criminal process.
Does he know he's being accused as opposed to being investigated?
Again, that's a difference of terminology. He knows he is under investigation, and that is because an accusation has been laid against him by the young girl.
Yes, so
he does not.
The accused is the accusation by the young girl. Yeah.
Yes, he does. I do not mean by that he has been accused in the sense of charged, or that he is an accused in a criminal process.
Mr. Fitzgerald says we're coming back now from what we might call the full-blown information given about trial dates, trial in absence. And in a sense, one's pulling back as to what becomes the trigger point.
Yes.
Now, he's given us, in a sense, a trigger point as a fallback position, which is that there must at least be prosecution, charge, whatever you want to call it. Your trigger point is somewhere in the criminal justice system. And at the moment, I'm struggling to precisely pin that down as a concept that one could really put forward.
What I was seeking to express, and I accept that it's not easy to know where the cut-off comes, is that you are sufficiently informed that you, not that just an offence has been committed, but that you have been accused by someone, and that the authorities have required you to stay in touch so that they can serve process on you, and you've been required to identify a lawyer. That's the facts of this case. Now, arguably, and on the authorities, your cut-off could come even earlier than that. But for these purposes, that's the facts of this case, and these are all fact-specific. It will be the case that if you are looking at the optional ground for non-return, you are looking at the individual facts of every case. So, as I said at the start, I accept that the difficult issue of general public importance is exactly when. And I would formulate it something along the lines of, at the point when you are sufficiently informed of the jeopardy in which you stand, that if you remove yourself from the possibility of knowing more, if you have the means of knowledge and you remove yourself from the possibility of being fully and properly informed, you are exercising what Dziehl calls Nelsonian blindness, or what Dworzecki says, you are seeking to avoid service. And what the recital to the FD 2009 calls a manifest lack of diligence, I better give you the exact words, particular attention could, where appropriate, be paid to the diligence exercised by the person concerned in order to receive information addressed to him. And that's not the information, or specific information about trial, or separate information about consequences of non-appearance. It's all information. There's no definite article there.
What's the page reference?
Sorry, 436. And it's the last part of recital 8 in FD 2009. It was Mr. Justice Carr in Biakalski, which I think perhaps we haven't looked at yet, which is at tab 40, 1040, starting at page 1075. Sorry, Biakalski.
Biakalski is 1070.
Yes. Tab 40, page 1070, at paragraph 34, 1075. It was Mr. Justice Carr who said that there was no real difference between knowing and deliberately non-attending and deliberately not knowing. So in paragraph 35, he said, it would be difficult to be sure on the facts of this case whether the requested person knew the trial dates and deliberately did not attend on those dates, or whether he deliberately avoided knowing what the dates were because he didn't want to know what they were. Either will do. So that is a Nelsonian blindness. It's a deliberate decision to put yourself in a position where you cannot receive information, either as to the date of trial or, in my submission, as to the consequences of not attending. What happened in this case, as I've said, is that the writ of summons, which includes in terms the consequences of not attending, was served both on the court-appointed lawyer who Mr. Bertino had said he wanted to represent him. I don't suggest he knew which court-appointed lawyer it was, but he had delegated a choice of lawyer, and also served on him himself at the address which he had notified for that very purpose. But of course he didn't, or says he didn't, get it. And certainly he didn't respond to it. Can I now go in similar vein, or before I should, I had set out a list of the possible points in an investigation process. And you start at one end of my spectrum with no information at all about an accusation or an investigation, still less a trial. Then you get to a point where an investigation is opened and is in process, which is certainly the case for Mr. Bertino. Then you get to a point where there is an investigation plus personal contact between the requested person and the police. Again, it's the case in this case. Then you might have information about the investigation plus personal contact with the police, plus obligations either of bail in this country or obligations to notify address and more specifically change of address. Then you might have information about investigation plus contact with the police plus obligation to stay in touch plus a warning that if you don't do that there will be consequences, such as in this case the fact that all documents will be served on the court-appointed lawyer. And then you have, so to speak, your Article 4A gold standard personal service of a summons, including an explicit warning as to trial in absentia. And going back to what I said much earlier, in my submission, it's perfectly proper to set your cut-off point at an early stage in those various processes, partly because what you're aiming at is to protect against the possibility of serving a sentence about which you knew nothing at all, partly because what you're engaged in is an extradition process where you can have the confidence that Article 6 rights have already been respected in the issuing state, and finally, because you are in the extradition process and you can also have confidence that if there was any doubt about those Article 6 rights being properly respected in the first place, there are remedies in the issuing state. As it was put in Cretu, the requested person will not be helpless if everything has gone wrong and his Article 6 rights have not been respected. And as we put it in the case, specifically because of the directly effective directive in 2016, 343, which you can call upon as an individual when you return, if that is appropriate on the facts.
Can I just ask, in your different stages, when you say personal service of summons, do you mean at the point beyond the charge or decision to prosecute? What do you mean by summons?
The summons, I was using the term as it's used in this case, which is the decision to prosecute. That was because despite the wording that investigation continues, there is a request for further information in this case, and the answer came back. I think Mr. Fitzgerald took you to it in the very early stages this morning. The investigation concluded and the trial process started in June of 2017. In fact, there was a first trial date fixed in 28th of September. Mr. Bertino didn't appear. It was adjourned for his further appearance to December, and they didn't start hearing evidence until December 2017. But they set the date at that stage.
Are there any Strasbourg authorities in relation to those different stages?
No, those are entirely my stages, and they come very largely from this. So there are no Strasbourg authorities that directly relate to this, no. They come from the facts of this case. My Lord, may I take you to Striecki, which is at tab 34, page 963. And this is for the purpose of looking at Mr. Justice Higginbotham's paragraphs, subparagraphs at 50, 1 to 7, because they've received a certain amount of judicial attention and attention from my learned friend. And particularly it's 5, 6, and 7. There is no dispute, again, I think what I've called the gold standard, that 5 is the ideal at which you're aiming. Summoned in person means personally served with the information and or the requesting authority must unequivocally establish the person actually received the relevant information. Agreed. That, of course, that satisfies 4A. That box would be ticked, and that would be the end of the matter. 6, he goes on, establishment of the fact that the requested person has taken steps which make it difficult or impossible for the requesting state to serve the requested person with documents which would have notified him of the fact, date, and place of trial is not in itself proof that he's deliberately absented himself from trial. Now, learned friend, for obvious reasons, relies on that. That specific subparagraph has been the subject of judicial comment in, 5 cases that I'm aware of. Tirakowski, where it was, I think, politely doubted by Mr. Justice Knowles. Dzieł,
Give the name again.
yes, Tirakoski, my pronunciation may be wrong, it's at tab 36, 1005, at paragraphs 29 and 30, which are at 1015. In Dzieł, where Mr. Justice Ousley shared Mr. Justice Julian Knowles' concern, and the reference for that is 38, page 1040, at paragraph 17, page 1049. Zatkowski, by contrast, a divisional court decision of Lord Justice Irwin and Mr. Justice Stuart Smith, endorsed all 7 paragraphs without apparently having had the other 2 cases drawn to their attention. And the reference to that is tab 39, 1056, at paragraph 22, page 1063. Biakalski, the one we looked at earlier, Mr. Justice Carr, now he agreed with 7 and reconciled subparagraph 6 with Cretu on the basis that a requesting state can't prove deliberate absence just by proving that a requested person acted evasively. It also has to prove it itself took steps to acquaint a non-evasive accused with the time and place of trial. Reference for that being tab 40, 1070, paragraphs 26 to 27 at page 1074. And finally, in this case, in the appeal court, which is at page 154 of the bundle, paragraphs, well, it's 28 to 32 at page 171. Those are all judicial comment on whether this is or is not correct. But may I hope with great respect, suggest a further reading of it, or I hope a literal reading of it. Establishment of the fact that the requested person has taken steps which make it difficult or impossible to serve him is not of itself proof that he has deliberately absented himself from trial. With respect, that must be entirely correct, because that doesn't imply any fault, any manifest lack of diligence, necessarily any evasiveness. And I'm thinking, for instance, of a simple example. An offence is committed in your hometown. Within a month or 2, your partner is given a job in Germany, and you move to Germany, the pair of you. That has, in fact, made it difficult or impossible for the requesting state to serve you, but not because you are deliberately absent within the terminology of Section 20, but simply because you're outside the jurisdiction. You're not trying to avoid anything, you may not even have known, but you have, in fact, made it difficult or possible. Now, it's not for me to say what Mr. Justice Higginbottom meant, but that is entirely logical and would explain, in my submission, a possible answer for what he meant there. And then he goes on, the final subparagraph is the requesting authority cannot find you because of a manifest lack of diligence on the part of the requested person, notably where you sought to avoid service of the information. There clearly you are within deliberate absence. So the fault led the person to be fault of the person led him to be unaware of the time and place of trial. And indeed, I would say further than that, also of the consequence of his failure to attend. May I move on, please, therefore? It is my submission that you must either know of the trial or the hearing, or you must have had the means of knowledge, and you have deliberately put yourself outside the process that allows you to receive that knowledge. You have deliberately refused to engage with any means of acquiring knowledge. In that case, in my submission, it doesn't matter exactly what the knowledge is, whether it's the precise date of trial or an adjourned trial, or the consequences of what would happen if you don't attend. Mr. Justice Swift, in this case, said there's no relevant distinction. This is at paragraph 25, page 170 of the bundle. There's no relevant distinction between knowledge of the date and place of trial and knowledge that a trial may take place if you don't attend. If the cut-off point has come prior to the formal service of the writ, in this case, then you take the risk by your deliberate actions to avoid receiving information, you take the risk of the consequences that follow. And the difference in terms of reasonable foreseeability, and I'll come back to how you test knowledge or means of knowledge, but the difference, of course, in Jones is the one case where not even the trial judge knew whether somebody in this country could be tried in their absence. That's an extraordinarily rare case, and that's the reasonably foreseeable test. The fact that you don't know you could be tried in absence because you've refused to engage with the means of being warned of that very fact it is, or for it to be literally a get-out-of-jail-free card, means that it would be a very rare instance in international law, let alone domestic law, where ignorance of the law gave you a full answer. Mr. Justice Swift deprecated learned friends' attempts to separate the question of knowledge of trial and knowledge of the consequences of non-appearance, and said that recital 8 couldn't be read that high. But if I am correct that you can set the line of deliberate absence at an earlier stage than the decision to try you, then by definition you are setting it also at the stage where you don't know you can be tried in absence. And if it turns out that your rights are breached and that is wrong under the law of the issuing state, then you have your remedy there. So I move to how you test or evaluate knowledge and means of knowledge. First of all, of course, from the EAW. If that is filled out properly, it's conclusive, and that's the end of it. But in the case of ambiguity, then you test it from all the facts that are available, and that would include the response to any request for further information, whatever is known about the chronology in the requesting state, any statement made by the requested person, and it includes what was reasonably foreseeable. Now, whether that is subjective or objective is a matter of dispute between the parties. I do not accept that it can be entirely subjective. First of all, for the reason that's set out in Dazil at paragraph 39, page 1054, that if you are making a decision about what is reasonably foreseeable, you are by definition judging what would be reasonably foreseen by any normally rational, averagely intelligent human being.
So it's implicit in the test?
Yes, exactly. And it may be, you may have to derogate from that test in a particular case. You might, at one end of the scale, have a requested person who has been in trouble for the whole of his adult life, for the last 60 years, who knows the criminal process in the requesting state better than any member before the lower court in Westminster, and who is therefore credited with an enhanced level of foreseeability or ability to foresee. But you may equally be dealing with somebody with no previous convictions who has significant mental issues, who might be a person with a mental age of a child, and you would have to rein back what you thought was reasonably foreseen by him. In other words, not test it against simply the normal rational
So
average.
you don't just look to the reasonable man, you might look to an objective test applied to someone with the characteristics, someone in the shoes of that person with his characteristics.
Yes, which would be in keeping with what we do in the criminal courts in any event. And I entirely accept it's not a set test, but your starting point of what was reasonably foreseen is what is generally reasonably foreseeable. I've already said I accept that deliberate for 23 means non-accidental, means it's something more than just accident or total recklessness. There's one other point to make about subjective, a wholly subjective test. And that's to come back to the fact that not only is this in the context of criminal proceedings, but it's in the context of an extradition request. Nobody can force a requested person into the witness box any more than you can force a criminal defendant into the witness box. You can't even ask, or at least there's no statutory basis for asking a district judge to draw inferences against somebody. If the test is to be purely subjective, then it's most unlikely that any requested person is going to be giving evidence, certainly not choosing to give oral evidence and opening themselves up to cross-examination. And in effect, you make it practically, by which I mean in practice, impossible to prove to the requisite standard what he did or didn't know 5 or 6 or 7 years ago in a different country.
Well, if you have a subjective understanding, whether it's genuine or not, can certainly be measured against what is objectively the conclusion that would be arrived at. And that is the same test used in relation to self-defense, for instance.
Well, yes, certainly. But you do create significant problems.
He doesn't get into the witness box, and all you're left with is what would normally occur.
Well, if he doesn't get into the witness box and the EAW is not clear, and you have, as is so often the case, partial information as to what is in a domestic file in a foreign state, there is going to be at least a large proportion of cases where you say, I can't be sure to the criminal standard that he was deliberately absent because I just don't know what was in his mind. It may be that there would be a level of cynicism or skepticism, but I am uncomfortable with the prospect of, in effect, forcing a requested person to give evidence and be cross-examined, or at least raising the stakes in terms of him doing that. In order to establish what should, after all, be a matter more or less of, well, a matter literally of box ticking, or at any rate of fairly unobjectionable agreement. I don't have the feeling that I've properly answered your Lordship's question.
It's entirely my fault.
And that can't be true. I think I can skip it. I've already referred to the recitals, the particular recital 8 in the framework decision. I've referred to the 2016 directive, which acts as a fail-safe if, in fact, the decision taken in this country has been unjust. Recital 38 of that directive raises the question, which is worth just a moment's consideration. Framework decision 2016-343 at page 456 of the bundle. Sorry? Thank you. Recital 38, this is one with an extraordinary number of recitals, but recital 38 being at page 460, when considering whether the way in which information is provided is sufficient to ensure the person's awareness of trial, particular attention should, where appropriate, be paid to the diligence exercised by the public authorities to inform him and to the diligence exercised by the person concerned in order to receive information addressed to him. Now, we've dealt already with the second half of that, the person's diligence, but I would accept that the diligence of the requesting state to find somebody is a matter of relevance. That goes back to the case of Kolotza, who in fact died in prison whilst subject to an in absentia conviction, as I recall, and it was found, as a matter of fact, that the authorities had every means of finding him, that the same judicial authority had served process on him properly at his address, I think only 2 months before they said they'd failed to find him. And one of the points in that case was that the requesting authorities had simply not used sufficient diligence.
How does that fit into the concept of waiver, if you could help me there? Because my understanding was that the various categories you set out were examples of the individual potentially waiving his right to be present at trial. And so that in applying those tests, you look at foreseeability and diligence of the individual.
Yes.
How does diligence of the requesting state come into the question of waiver?
It doesn't directly, but where it becomes relevant is whether, well, in a sense, it goes back to the commentary of Mr. Justice Carr on the Higginbottom subsection in Striecki, which is it's not enough just that somebody has made it difficult to be found or to be contacted. It must also be shown that the authorities have put in train sufficient efforts that they would have contacted a non-evasive defendant. So in this case, if the authorities have made, or it is not open to authorities to rely on simply making no effort at all, except saying something like, well, we've written your name up on a list of accused persons at City Hall, which I think was one of the things they'd done in Kolotza. And if you didn't happen to be passing Rome City Hall at the relevant moment, that's your tough luck. They have to have taken active steps to find him and to ensure proper service. And indeed, the recitals say, and the cases say, that excuse me, the member states must have in their criminal process proper means of ensuring, so far as they can, that persons are made aware of trials that are being brought against them. So it's not directly to do with waiver, because that's the next stage. But if you can't waive that which the authorities have made no efforts to tell you about. And per contra, if the authorities have made considerable efforts, and in this case there were 12 searches, there was surveillance carried out, there were inquiries with the appellant's mother and wife. If you have gone to proper lengths to try and contact somebody, and in the absence of all of that, and in light of a lack of diligence by the requested person, he hasn't been fully informed, then that goes to whether he's effectively waived.
I do apologise for interrupting, but what are the minimum safeguards commensurate to the importance of that have to be protected? So a waiver of the right to take part in a trial must be established in an unequivocal manner and be attended by minimum safeguards commensurate to its importance. What are the minimum safeguards commensurate to its importance?
The most obvious one is the point we're discussing. That,
Indeed. Yeah. Anything else?
That people have, well, first, that you have actively tried to tell somebody. Second, that if, despite your best endeavours and despite what you think at the time is deliberate absence, it turns out that there is a blamelessness. The Italian law talks about a blameless nature, or I can't remember the exact word, but if it turns out that actually, unbeknownst to anybody, the requested person was in a coma in hospital, or, as in one case, unable to attend trial because they were in prison in a different state, and they indicated their fervent desire to attend, but were not able to, or in a third case, that the requested person had been excluded from Bulgaria, I think it was Bulgaria, by one arm of the state because of offences committed there, and was forbidden from returning to face trial. If, in other words, after you've taken the decision and you've gone ahead and tried somebody, it turns out that that was unwarranted and there has been a breach of rights, then the answer is a retrial. Or retrial or a rehearing, at which guilt and innocence can be reconsidered.
How are we to look at that in this particular appeal? You've submitted in writing and orally that the directive provides rights if the requested person is sent to the requesting state. The cure for the problem that you're identifying, as you've just indicated, is a retrial. But in this case, and it's another one of the curiosities of the factual mess that we face, a retrial is off the table.
Well, that's not strictly true, as I understand it, but I will be corrected if I'm wrong, because the two people who know are to my left. A retrial is not off the table when he goes back to Italy. If he goes back to Italy. What was off the table, and because for an access of fairness or whatever other reason, because it was not argued here, was that a retrial was the answer to the English court's dilemmas in this case. So I don't think anybody has said Mr. Bertino will not and would not, in appropriate circumstances, be entitled to a retrial. It was not argued in the lower court that that was an option, and so Section 20, subsection 5 was never considered. There was a brief flirtation with the question of retrial at the High Court stage.
Yes.
And it was, if I may say so, fairly withdrawn by the CPS as an option of something that they were going to argue here because it hadn't been dealt with earlier. But as a matter of law, and certainly as a matter of Italian law, I know of no reason why, if he...
Well, there's been no finding.
But there wouldn't be in this country. There wouldn't be a finding in this country that is binding on the Italian court.
I don't know, but there would be a finding that informed a decision in this court if it decided to send somebody on the basis that he or she was going to be retried.
Oh, I'm sorry, I've misunderstood.
Yes,
I'm not suggesting you send him on that basis. We're way beyond that point. It's Section 20, subsection 3 or nothing.
Well, that's what I wanted.
That's
Yes.
another way of saying that retrial is off the table for our consideration, isn't it?
Yes, I misunderstood. I thought you meant, is he debarred from raising that in the foreign state, just as is he debarred from relying on Directive 2016-343? Answer, no. If he is sent back, those rights are open to him, and they might act as some comfort, but I am not for a moment suggesting that you look at or make any decision as to whether he's entitled to a retrial.
Preventing the judicial authority issuing another European arrest warrant and ticking the right box. And you go straight back.
Yes, under the new treaty, yes. As a matter of fact, that is correct.
Yeah.
It doesn't, and it answers the point in this case, it doesn't give the answer to the question of some significance, and this is the first time that, since 2003, that this court has looked at Section 20. So for broader reasons, I'm not encouraging that as a simple answer, although it may be a practical answer.
If one is balancing the public interest, the people actually accused of crimes are properly convicted of them, against the other interest that those people who are accused of crimes can participate in their trials. If there is a simple solution for the requesting state, why not adopt it?
Well, I can see some force in that. It is one of the ironies of the case today and indeed the case tomorrow, although I won't trespass on that, that had a box been ticked in the European arrest warrant, none of this investigation would be taking place. And
your client has invited it.
Yes. Well, actually, it was the appellant who invited it, but yes. If there is a factual unfairness underpinning the chronology in this case, it would never have been investigated if a police officer in Italy had put one tick in one box. So factually, Mr. Bertino is in a great deal better position in terms of the consideration of his rights by virtue of what we are engaged in than he might otherwise have been. But anyway, that's perhaps a comment that doesn't advance the case very much. My Lords, I'm almost at a conclusion. May I make one comment only about the only reasonable inference point, and that is to clarify, I hope it's already clear in the case, but this phrase, the only reasonable inference, is something that comes from the case of Assange. It has been used time and again in extradition cases since then, but it was used in a very specific context there, which was a missing part of the conduct where you are looking at dual criminality. And the question was whether you could fill that gap if there was only one ineluctable inference that allowed you, for purposes of English law terms, to reach the conclusion that dual criminality applied. We're not in that territory, and I don't think Mr. Fitzgerald suggests we are. And there's not a great deal between us on the inference point. I would accept that if there are several equally valid inferences, and that's the stress, then the requesting state wouldn't have satisfied the burden and standard of proof. It has to be a reasonable inference, not a wholly unreasonable one, and it is looked at in the context of all of the other facts. So I don't go so far as to say it's the only inference, but I do accept that if there are two equal, wholly opposing, and equally reasonable inferences, then we haven't satisfied the burden of proof. So I don't think there's very much between us on that, and I'm not going to dwell on it further. The final thing, then, I was going to do was to look at the relevant facts in this particular case.
Sorry, if we're moving on to the facts, can I just ask you a question about the law? I mean, I've been looking at the Sedgwick case.
Yes.
I mean, I don't know if this is the leading authority. It hasn't been explained to us, but it certainly looks like an important authority, beginning at 1197, where the court is examining general principles concerning trial in absentia, right to take part in the hearing and to obtain a new trial. Paragraph 84, for example, duty to guarantee the right of a criminal defendant to be present in the courtroom, either during the original proceedings or in a retrial, ranks as one of the essential requirements of Article 6. Accordingly, the refusal to reopen proceedings conducted in the accused's absence without any indication the accused has waived his or her right to be present during the trial has been found to be a flagrant denial of justice, rendering the proceedings manifestly contrary to the provisions of Article 6. Now, that seems to say either you have a trial in the first place with the defendant present, or if they're tried in absentia, there has to be a retrial, the only qualification to that being a waiver of the right. But when one goes on, we see under the next heading, waiver of the right to appear at the trial. It says, paragraph 86, if it's to be effective for convention purposes, a waiver of the right to take part in the trial must be established in an unequivocal manner and be attended by minimum safeguards commensurate to its importance. Well, isn't it difficult to say that that standard's been met in this case?
With respect, no. First of all, the facts of Sedgwick were that he had disappeared shortly after a murder.
Sure, but...
without...
Sorry, you're gone.
I was going to say, without having been any part of the criminal justice process. You then go... the Italian... Sorry, I'm looking at paragraph 8 and following.
Can you help us with the page for that?
Yes, sorry, 1185.
Thank you very much.
A gentleman was fatally injured by a shot. A Rome investigating judge made an order for this applicant's detention, but the applicant had become untraceable. So he was never stopped, interviewed, identified, questioned, relevant evidence taken from him. And they then carried out a trial in his absence. And this was in 2006, before the Italian law changed. He wasn't in paragraph 96, he hadn't been informed about a charge, he hadn't been informed about a date of trial. Paragraph 99, they relied on vague informal notice not being enough. and decided that it couldn't be inferred merely from his fugitive status that he'd waived the right to appear. That was 87 and 100. He must reasonably have foreseen the consequences. Paragraph 87. Now, just before the bit where my Lord Sales was reading from, paragraph 82, proceedings that take place in an accused's absence are not of themselves incompatible with Article 6, but a denial of justice nevertheless undoubtedly occurs if convicted in absence and unable to obtain a fresh determination, in other words, a retrial, unless it's been established that he has waived his right to appear, or, and this is the bit that I rely on, that he intended to escape trial. And again, in paragraph 83, the Convention leaves contracting states a wide discretion as regards the choice of means calculated to ensure that their legal systems are in compliance with Article 6. The court's task is to determine whether the result called for has been achieved. In particular, the procedural means offered by domestic law and practice must be shown to be effective, where he has neither waived his right to appear nor sought to escape trial. So there is, in my submission, an equivalence between intending to escape trial or seeking to escape trial and deliberate absence in section 20, subsection 3, in contrast to a lack of information which leads either to a breach of your Article 6 rights or to the necessity for a retrial.
Do we have Somergy in the papers?
I did ask about that, and I think the answer is no. Was that one of the ones that's not reported?
Do we have
Medenica we certainly don't have, and it's not reported, and we couldn't find a report of it. Medenica was against Switzerland, and we looked for that explicitly. We can, well...
So does your submission come down to this, that either there has to be a waiver in the full sense indicated by the court of the right to appear at trial, or it has to be proved that the defendant intended to escape trial? It's one or the other, is that right?
Well, it's not really one or the other, because a waiver, unless by waiver you mean an explicit statement of waiving of rights signed to, the tacit waiver is the same as, or is proved by, evidence that somebody sought to evade trial. So there's no distinction between those two. And it is again the same in my submission as deliberate absence. Those are all different ways of saying the same thing.
Yes, thank you.
we have Kat Owoska in the papers either?
Sorry,
Paragraph 86, third line.
I'm told no is the answer. No. But that is, that statement is certainly undisputed, but also very common, and that statement is repeated in the recital to...
How it works out in the decided cases.
Yes, I'm sorry, I wasn't suggesting it was unnecessary, and we can undoubtedly do our best to find it. I'm just trying to find the references, but the statement that, in fact, it appears in dozens of cases that there is nothing that stops a defendant. He has a right to be present at trial, but there's nothing that requires him to be there. But that expression, neither the letter nor the spirit of Article 6 prevents a person from waiving of his own free will, expressively or tacitly, is specifically repeated in one of the recitals. Do you know where? Well, it's in recital 1. Sorry. Sorry. I was going to say it's in recital 1 of the framework decision 09. The court has declared, that's the Strasbourg court, has declared the right of the accused person to appear at trial is not absolute, and under certain conditions the accused person may of his or her own will explicitly or tacitly but unequivocally waive that right.
Yes, the same text appears in recital 35 of the 2016 directive.
Yes, thank you. At page 460, yes. So, Lord, lastly, I was going to look at the facts of the case, not in great detail, but in terms of notification of the investigation to the appellant. Each of these cases turns on their facts, and it is in my submission significant that within 24 hours of the offence being committed by him texting the minor, he was visited at work by the police, he was searched, and he had his mobile taken from him. That mobile, and it must be to his certain knowledge, contained the full evidence of obscene text sent to the child. It would seem that no further evidence was necessary for trial, and that is relevant because he says he had instructed his own lawyer.
How do we know it's got any evidence on it at all?
Because it's in the judgment, in the Italian judgment. Can you find the reference? He was sacked there and then as a result of the offending. As we've already said, his own evidence is he was arrested and questioned that day, but there's no such evidence from the Italians. That was all going on in Venice. A month later, on the 23rd of July, by which time he was at the other end of Italy in Sicily, he was required to attend the local police station where he signed the form that we've looked at more than once. It is headed Record of Declaration of Domicile for Service of Process. He signed it in front of a witness. It was read out to him before signing. He was told that investigations were being conducted against him. He was told that on the 28th of June, so just 8 days after the police had taken his mobile, the Venice province police had sent the notitia criminis to the public prosecutor's office in the province of Venice in Pordenone. He declared the domicile for the service. He was warned that as he was being investigated, he was under an obligation to notify change of declared domicile. He was told, and this is important, how he had to do that, by rendering the new address to the judicial authority in charge, and warned that if he failed to notify change of address, the service of documents would be executed by delivery to the defence lawyer of choice or court appointed. Can I digress for a moment on the question of address, simply to point out that there is some confusion about what address, if any, he declared to the Sicily police before he left in 2015. He said, and it wasn't a point disputed, that for the purpose of family proceedings, he had told some police somewhere, presumably in Sicily, that he was going to the UK before he left in 2015. may I ask you to look briefly at page 243 and to have a thumb in 251, because his proof of evidence served in the lower court and not disputed gives 4 different addresses at which he'd lived in this country. When he first moved to England, he says he lived in a shared house in Scunthorpe, and then his children joined him, and he moved to a house in Ashby in Lincolnshire. That's paragraph 5, I'm sorry. Paragraph 6, I've lived in Lincolnshire for 5 years. Other than the period I lived with the children in Ashby, I've lived in Scunthorpe for the entire period. In one house for 1 year, then I moved in with a friend for 2.5 years, and I now rent a room in a 5-bedroom house with the same friend and others. So there are 4 different addresses he'd lived at in this country. In cross-examination, and this is 251, he says that the address he gave before he left Sicily was Frodingham Road in Scunthorpe, the same address where I'm tagged. So, by definition, that's the 4th address, it would seem, the one at which he's living as part of his bail conditions. Logically, it cannot have been the address that he gave in 2015, if he did give any police officer his address. Furthermore, the EAW names what looks like a partial address in Church Square House 30 in Scunthorpe as his known address as far as the Italians are concerned. And then finally, I'm sorry, so the EAW, which is at page 191, in the middle of that page, names Church Square House 30, Scunthorpe, as his residence or known address. And finally, at 226, as part of the record of searches carried out by the Spadafora police, it says it's the 1, 2, 3, the 3rd dash after the 2nd bullet point, if that makes sense, on page 266, that following a telephone call as of January of 2019, contact details in the United Kingdom, Church Square House 30, Scunthorpe, were given. So that is after trial. That is the moment where the Italians appear to get the first information that he is in the United Kingdom and an address. On his evidence, that's not the address he gave to anybody. His evidence doesn't seem to tie in with the facts if he says he gave the Italians the address at which he is now tagged. But this may have some relevance to the fact that he himself talks about a telephone call with police when his mother handed the phone over to him. And as a very small point, may I just identify there was an issue that my Lord Hodge raised about 235, the writ of summons appearing to stop in the middle of a sentence. It's repeated again on 236 and 237. Oh. So insofar as it stops, I'm afraid I don't know why it's in that form on 235, but the full comment is set out under the heading requests, and 236 goes on to 237. Excuse me.
Thank you very much.
So the end result of all of that is, well, it's probably just further confusion. But at any rate, the short answer is he does not appear to have identified to police before he left any address at which the Italians could find him, leaving aside the fact that the requirement on him, on the form which he was given to take away, was that he told not some random officer in Sicily engaged in family law proceedings, but the judicial authority in Venice that were investigating and prosecuting him, or investigating and considering prosecuting him, more accurately.
And it was the judicial authority in Venice as opposed to in Sicily?
Absolutely. It was in Pordenone. And I am...
In Sicily, the police were involved, but the judicial authority was always in Venice.
Always in Venice. Pordenone, which is, I looked it up, so it's just outside Venice, inland from. That's where he was working in the holiday camp. When he's sacked, he goes home to Sicily. The Sicilian police call him in to sign the declaration of domicile, but throughout, the judicial authority and the public prosecutor are in Venice.
We don't need to know the relevant rules of procedure because whatever they are, he didn't follow them. Is that right?
I'm sorry, whatever they are.
He was to be rendered to the judicial authority in charge pursuant to the relevant rules of procedure. And
Yes.
it matters not because whatever the relevant rules of procedure are, he didn't follow them.
Quite. No. Sorry, I've lost my place. Oh, yes.
And would one of the safeguards be that you would have to inform somebody, getting them to tell the judicial authority, according to the relevant rules of procedure, exactly what those procedures were? Would that be a safeguard, a minimum safeguard?
No, in my submission, it would not. I mean, in fact, in this case, he could have asked the lawyer that he'd instructed, but if you inform the... Sorry, let me just turn up the actual words of what he signed. As long as you told the judicial authority, or even the public prosecutor's office at the court of Pordenone, that you had changed your address, it would be very difficult, I would have thought as a matter of fact, for a court subsequently to find that that showed such manifest lack of diligence that it amounted to deliberate absence. Can you find the bit in the judgment? These are the evidences, page 217, and then it produces all the text messages. Thank you. The reference for the judgment and the evidence of the text messages is 217 to 218, which reproduces and quotes from the text messages. They were seized from his phone. Seized from his phone, thank you. Yes, there was one further point which was raised by my Lord Burrows, which is the fact that it's clear from the declaration that he signed at page 205 that he did delegate a lawyer. He delegated, however, the court-appointed lawyer. I am not suggesting that there is any evidence that he gave instructions to an individual, although the individual represented him and is named. But the answer as to whether that would bring him within 4AB begs the question, because even if he delegated all his rights of defence to his lawyer, which he plainly did, he has to be aware of the scheduled date in order to fall within 4B, and for that to be an automatic ground to send him back.
What exactly do you mean by delegated in that context? Because surely what this is telling him is that if process follows, he can appoint his own lawyer, or if he doesn't appoint his own lawyer, one might be appointed for him. And the same point is made in the writ of summons, and perhaps more clearly, the accused has the right to appoint a private counsel, and in other words, appoint and pay for. Failing this, will be represented by a court-appointed defence counsel, so that's one paid for by the state. So he's got a choice, hasn't he? He can either pay for it himself, or he gets somebody appointed by the court. So it's not like the system here where you still appoint your own lawyer and you hope the legal aid fund pays. So I don't really understand what you mean by delegated, to be candid.
Well, two things. First of all, although it says that he was represented at the point of writ of summons by private counsel, by the lawyer named Andrea Di Roma, my understanding is that although they're described as private counsel, he was court-appointed.
Yes.
So I am not suggesting, as I've said, that there is any evidence he gave instructions. The most that he did is divest himself of responsibility, and I was picking up the word delegate from my Lord Barrows, that he delegated to that lawyer. He doesn't appear to have decided to take any efforts at all in relation to his lawyer. He wasn't told in 2015 that he might get a lawyer. He signed something that said, I will be assisted by the defence lawyer that will be appointed by the court. That's the bit in bold at the bottom of page 205.
How does he know which lawyer has been appointed by the court?
Unless he made the inquiry, he doesn't. That's why I'm saying I'm not suggesting he's given any instructions. I have no evidence that he's contacted that lawyer. The highest it can be put is he didn't want anything further to do with this process. He said, you can appoint who you like, and it's up to them what they do with my case.
Well, can you really take that from the thing signed in 2015? Is it? I think it was Mr. Justice Swift who was concerned about some of the quality of translation. I'm not going to look at the original, but does it mean anything more than I'm not in a position to pay for one myself?
Well, I'm not sure what the word mi avvalgo means, but certainly the defence lawyer, this is page, well, the Italian is at page 204. Il difensore che mi sarà nominato is the defence lawyer who will be nominated for me.
Yeah. Maybe we're getting into fine detail, but if one looks at the top, it's a declaration that says the possible appointment of a defence lawyer of choice.
Yes. Because at that stage, I mean, this document is clearly good for both.
Yeah.
And he hasn't decided, well, it would be good for somebody who appointed their own lawyer or for somebody who chose the opposite. But what they have filled in, I take to be the piece in bold. So this appears to be a pro forma, and the bits in bold are the ones that are filled in for this specific appellant. His name, the date and time of his attendance, the particular notitia criminis, and his decision at the first bullet point of electing domicile and choosing a court-appointed lawyer. But I don't try and take this very far. I am, as I say, I think I've said before, I have no evidence that he gave any instructions or even contacted that lawyer. The only odd aspect is in his cross-examination, where he talks about nothing having been notified to my appointed lawyer. But again, it's ambiguous as to whether what he meant there was his own one that he had paid for or the court one that he had not. Yes, I think I've effectively made the other points on evidence. He knew the police had spoken to his mother. He knew the police were looking for him. And he didn't, it would appear, make any active attempts to find out why. So we're left with a rhetorical question in a sense. What did he reasonably think was going on the 23rd of July? What purpose did he think he was declaring an address for service of process for? What process was involved? And for what reason was he appointing or electing a court-appointed lawyer other than to deal with the forthcoming proceedings?
I think that's just about your time up.
It is, and I have in fact finished. Thank you.
No, Mr. Fitzgerald exceeded his time by a couple of minutes, so you've used up your time now. Thank you very much. Mr. Fitzgerald.
Just on this concept of waiver, which my Lord Stevens put to my learned friend, the concept is one of the concept. Oh, sorry. Oh, good. The concept is one of waiver, and if one asks the question, "How do you waive?" The answer is in paragraph 86 of Sadovich in this context, and that's at tab 49 at page 1197. And my learned friend's been...
Paragraph?
It's paragraph 86.
86, thank
yes. At page 1197, my Lord, yes. So one has there...
Sorry, can you help us on the status of Sadovich? Is it the leading authority on trial in absentia, or are there others? I'm just trying to see, is it a Grand Chamber?
It is a Grand Chamber, yes, my Lord. You can see that at 1183. It is a Grand Chamber, yes.
And have there been subsequent Grand Chamber decisions dealing with that topic?
Not... No, I think this is... it's always cited,
right.
Although there was
Thank
some...
you.
One sees it is the Grand Chamber, and it is the one that is cited repeatedly as the leading authority. And my Lords, if one just looks there, there's a reference to, at paragraph 81, the object and purpose of the article taken as a whole show that a person charged is entitled to take part in the hearing. Then, at paragraph 86, neither the letter nor the spirit of Article 6 of the Convention prevents a person from waiving of his own free will, either expressly or tacitly, the entitlement to the guarantees of a fair trial. However, if it is to be effective for the Convention purposes, a waiver of the right to take part in the trial must be established in an unequivocal manner and be attended by minimum safeguards. And my Lord Stevens put to my learned friend, what are the attendant minimum safeguards? And we say that they must at least be that you have been, you know that you've been charged, you know that you are facing a trial, because then you know the things that you're waiving the right to be present for the trial of. It's not enough, as the judge found in this case, that criminal proceedings were a possibility. That's paragraph 8, page 180. And the minimum safeguards would presumably also involve taking legal advice. If you've got a charge, you've got something you can go to your lawyer and say, this is the charge, this is what I'm facing. Advise me. Or if you had a lawyer at the encounter on July the 23rd, but he didn't have a lawyer at the encounter on July the 23rd. He didn't have a charge. and he didn't have notice that he was going to be prosecuted. And the most that the judge could say in his findings, which my Lord Burnett helpfully drew my attention to, is he knew that criminal proceedings were a possibility. That's miles from you know all the relevant facts, you've got rights commensurate with the gravity of the thing, and you then waive it. This is implication piled on implication, really. And my learned friend trying to get out from cross-examination that he knew what the position was. So we do say that, as my Lord Burroughs put, at least it's clear. If you say you've got to have been charged, you've got to know that you are being prosecuted before you can unequivocally and knowingly, in a manner commensurate with the minimum safeguards fitting to the importance of the right, waive it. And so that's our respectful submission on that. He didn't we just make these points. He didn't have a lawyer. See page 205. He was not charged. He wasn't told you are going to be prosecuted, and the person was a judicial police officer, whatever that is, but he wasn't the judiciary. And it's clear that when he's under cross-examination, he's saying, and this is at page 251. That he considers that he had effectively told the people who were in charge that he'd moved. Now, let's just break it down to...
Sorry, Mr. Patrick, when you say he didn't have a lawyer, that brings to my mind the requirement to have a lawyer present during the course of an interview. Yes. And none of those authorities have been cited to us at all. When you say that it's a requirement, it's a minimum safeguard that when he was signing this document, he had a lawyer.
Yes.
Well, what's the authority for that?
No, I'm just, my Lord, if it were a charge,
yes.
If it's going to be treated as a charge or a formal accusation, then he would be entitled to a lawyer. And the point I was making may be a broad one, is if you've actually got a charge sheet, you've got something that you can go and...
you know what the sentences, potential sentences are going to be, you know what the offences are.
Yes, yes. You've got
a range of offences that might arise out of filming. Well, certainly in this country,
yes.
might be right.
Time and time again, people say, I've got my charge sheet, and the lawyer says, let me see the charge sheet, because usually they don't even understand what they're charged with. Let me see it, because I need to know exactly what you're charged with. So, my Lord, that's why on the facts, I've referred you to him thinking that by saying, I'm leaving the country, to the Spada Fora police, he was complying with the requirements. Now, my learned friend says, of course he wasn't. He should have known that he should have informed the Pordenone police, but it's not something that you would necessarily, you might just think it's the police. This guy was a judicial police officer, and that would be enough. And that's why it's got to be sufficiently formal in our respectful submission. Then my learned friend dealt with the case of Bicioch. We simply refer back to it in that case, which is at tab 27 in part 2. Your lordships have that. You can see that it refers back to Bletter, the case that my learned friend was asked about, at paragraph 9, and I think I took you to that. But Bletter is clearly not interpreting the directive, but interpreting the act. What does absenting yourself from trial mean? And that it's not enough that you deliberately absent yourself from the legal process, it must be the trial itself. And that is obviously picked up by my Lord Burnett in Cretu and approved. But that's what the judgment at paragraph 17, 872, says, I'm satisfied the proper interpretation of section 23 requires a minimum. A trial process must have been initiated from which the appellant has deliberately absented himself. So you've got Bletter, the very first case, pretty well, under interpreting the words of section 23, making sense of the words as words of in an English statute that trial means trial, not some vague process. That's picked up in Bicioch. Bicioch is approved in that respect by my Lord Burnett in Cretu, and we do respectfully submit that makes sense. That
can you just give me the reference for Blettrich again, please?
Bletter. Yes, my Lord, if you go back to paragraph 9 of Bicioch at page 867.
Thank you very much. That's
the key passage from Bletter is set out there. And all that is consistent with the meaning that you've got to deliberately absent yourself from trial rather than some trial process. So Bletter was an interpretation of the statute. And then Cretu, we say, effectively endorses that approach in Bletter to its trial process, and that's at page 922, at paragraph 34, subparagraph 1. Now, Zagreen, my learned friend took you to that, but in our respectful submission didn't answer the question of the wrong turning. I mean, we had the whole host of possible alternatives, and the spectrum from informed of something to actually informed of the fact that you're being prosecuted. But Zagreen leaves it perilously vague, that it's sufficient, and at paragraph 81, page 951, a requested person will be taken to have deliberately absented himself to trial where the fault was his own conduct in leading him to be unaware of the date and time of his trial. So that's any fault on your part at any stage which causally causes or contributes to, I suppose, your unawareness, means that you've waived your right to trial. That's essentially what that proposition means. And it was questioned immediately, in our respectful submission, correctly by Mr. Justice Collins in the next case, Lakatos. And to the extent that it was adopted and applied by the district judge and by Mr. Justice Swift in this case, we say it is a wrong turning, it is erroneous, it is too vague and broad. My Lords, the principle in Sajevich, I think I've now taken you to paragraphs 99 at 1199 and paragraph 101. I think I did take. Oh, okay. Oh, okay. So if we go to Sajevich, then Sajevich is at page 1199. One has 1199 paragraph 9. In previous cases concerning convictions of absentia, the court has held that to inform someone of a prosecution brought against him is a legal act of such importance that it must be carried out in accordance with procedural and substantive requirements capable of guaranteeing the effective exercise of the accused's rights. Vague and informal knowledge cannot suffice. And that is our point. Now, there are some examples given, only the last of which we would, or when materials are brought to the attention of the authorities which unequivocally show that he is aware of the proceedings pending against him and the charges he faces. That's the end of 99. But if you look for the one that they go for in the end, at paragraph 101, in those circumstances, the court considered that it has not been shown that the defendant had sufficient knowledge of his prosecution and of the charges against him. So you must know of your prosecution and the charge against him. It is therefore unable to conclude that he sought to evade trial, and re-emphasise the intentionality of seeking to evade, or unequivocally waived his right. So if you intentionally seek to evade trial or unequivocally waive your right to appear in court, and then in our respectful submission, that would be sufficient, but nothing less. And that fits in with our submission to the court.
But you refer to paragraph 99, and you stopped
Yes.
at T against Italy.
Yes.
The court went on. The court cannot, however, rule out the possibility that certain established facts might provide an unequivocal indication that the accused is aware of the existence of the criminal proceedings against him and of the nature and cause of the accusation, but doesn't intend to take part in the trial or wishes to escape prosecution. How do you qualify those words?
Must provide that the accused is aware of the existence of the criminal proceedings against him. Well, it's got to be unequivocally proved that he is aware of the existence of the criminal proceedings against him, the nature and cause of the accusation, and does not intend to take part in the trial. There would need to be, in our respectful submission, a trial which he doesn't intend to take part in.
Yes, but in this case, the declaration might be, while a charge had not yet been brought, but it might be within the terms of criminal proceedings in the sense that it's a preliminary phase, and he would undoubtedly know the nature and cause of the accusation against him, in the sense that that he knew what the young girl was saying, and he had his phone taken from him for that purpose.
But my lord, then it goes on, and does not intend to take part in the trial, and there's nothing that unequivocally points to him not intending to take part in the trial, because he's not aware of the fact that he will be put. I mean, at that stage, the reason why they're saying they're still investigating and we'll get back to you, and they don't get back to him for 2 years, or don't get back to anybody for 2 years, is surely that there are a number of possibilities. One is that it simply doesn't go ahead, the case, for some evidential reason or some reason to do with the reluctance of the complainant, or whatever it is. Countless sexual matters are not proceeded with, or some other policy reason. But you couldn't say that he was unequivocally aware of the criminal proceedings against him, because he was being investigated at this stage, and you couldn't unequivocally say he does not intend to take part in the trial. Or wishes to escape prosecution. I mean, that I accept looks that's so vague, but he doesn't even know he's going to be prosecuted. But certainly does not intend to take part in the trial is not covered. And then if one looks at, they seem to be drawing together all those possibilities in a formulation at 101. In those circumstances, which is the ratio, Cook has not been shown that the applicant had sufficient knowledge of his prosecution and of the charges against him. Well, both of those dicta would apply. In this case, there's no knowledge of the prosecution because it's not clear there will be one. There's no knowledge of the charges against him because there aren't any. Therefore, unable to conclude he sought to evade trial or unequivocally waived his right. My lord, that's really what we rely on, is paragraph 101 as the ratio decidendi and as equally applicable in this case.
Okay.
My lord, T in Italy, it's at was referred to. That's where they weren't contacted by the authorities, but you must be. The test was you must be formally informed of the prosecution process. And my lord, some of these from then on are in fact incorporated in our reply. If I can just give you the references in our reply at A11, we've set out the case of T in Italy, and that page. Page 10 at the bottom, the internal, paragraph 4.5. he must be formally informed of the prosecution brought against him before his absence from trial could equate to deliberate act of waiver. And then we've also referred the court, I think my learned friend dealt with the case of IR at tab 71, which concluded a waiver can only be inferred where a person who receives sufficient information to know that he or she was going to be brought to trial, and by deliberate acts and with the intention of evading justice, prevented the authorities from informing him of that trial in due time. So that's, you know you're being tried, you know you're being prosecuted, but you frustrate the information about the date of the trial. So we say that criterion, if applied, would mean that he had not waived his right to a trial in this case. My Lord, I think my learned friend did refer you to Zeal, and we've dealt with that at 4.8, and we just make the simple point. We say it was wrongly decided to the extent that it follows a green, but in that case there's a factual distinction because he knew that he was to be tried. My Lord, I've already dealt with the case of Prosecutor, which we deal with at A12, in which my learned friend referred to, and you have our submissions on, say, green. The one point in our written reply, and indeed in our case, I think my learned friend did not deal with, is the case of JK, which we set out at 4.11, page A12. And that case is the case where Lord Justice Singh and Mr. Justice Knowles focused on whether the requested person knowingly waived his right to attend his trial. That's at tab 37 of the bundle. And I can give you the page number. It's, yes, the key passage is at page 1034. 1034, paragraph 49. The position has recently and helpfully been summarised by my Lord Mr. Justice Julian Knowles. My learned friend did refer to Tirakovsky. I would note 2 points. First, the burden lies on the requesting state to prove to the criminal standard the respondent did deliberately absent himself from his trial. Secondly, what is required is ultimately an answer to the question whether the requested person has knowingly waived his right to a trial. Questions of manifest lack of diligence, for example, can be taken into account, but are evidential matters which go to answering the ultimate question. Well, that's our respectful submission, that what could reasonably be foreseen would, on English law principles, be evidence of what the individual must have foreseen, but are not in themselves the test. And so that manifest lack of diligence has to be interpreted in our respectful submission to mean deliberately closing or deliberately evading justice, as it were. Applying those principles to the facts of the present case, I do not consider this has been established. In my judgment, the district judge ought to have decided the question differently. He acknowledged that the summons was not served on the appellant. The appellant had put in place arrangements which he described as giving a power of attorney to his father. In fact, the summons was not collected, but it's not clear why. In those circumstances, I've come to the conclusion it was not established to the requisite standard this appellant had knowingly waived his right to a trial. Some might say that what he'd done was insufficient. Others might say that he'd done was foolhardy. At the end of the day, it does not, in my judgment, amount to a conclusion that he had knowingly waived his right to a trial and therefore had deliberately absented himself from trial. We would respectfully submit that is the approach, and that therefore, to the extent that Mr. Justice Swift, particularly at paragraph 36, which I showed you this morning, is relying on, as it were, lack of diligence, he is getting the test wrong, both because there'd been no charge or notification of a prosecution at that stage, and because it's only evidence. It's not of itself enough. I think, my lords, my learned friend took you to the case of Chihaya at paragraph 85 of Sunka. But we've made our submissions that we respectfully submit that the decision in Zagrin, Sunka and Chihaya is wrong to the extent that it suggests that any fault along the way which has causally resulted in unawareness is sufficient. And as my Lord Burroughs said, the advantage of prosecution or charge being the as it were, the bright line is it gives a clear indication rather than this, well, I think this may have contributed causally to him being absent and I think he failed in his duty, so that's enough. My Lords, I think those are the points. So of the various stages that my learned friend gave on her, as it were, spectrum, we say it's only where there is notice of a trial and a warning of the consequences that it's sufficient. You've seen JK, which we say supports that. I think I've put our submissions on the subjective objective in response to my learned friend. That's to say, you've got to either foresee it, actually foresee it, or be in a state of mind where you have foreclosed knowing the date of the trial by a deliberate intention to evade being given that knowledge. And that makes sense of the word deliberate in section 23, and it's consistent with Sejdovich and with all the cases in the European Court about Article 6, which say that it's about knowing an unequivocal waiver in circumstances commensurate with the gravity of the right at stake. So attended by procedural safeguards. My Lord, I think those are my submissions. Oh, I'm so sorry. Oh, I'm so sorry. My learned friend Helen Malcolm's just pointed out that the other Grand Chamber case is Idalov. I apologise, my Lord.
Sorry.
Idalov, IDALOV.
And what page number?
We've got that in the bundle.
The 6 years after Sejdovich, it's consistent. It's 54, page 1307, and the bit that deals with it is paragraphs 172 to 4 at page 1343 to 4.
1343.
Yes. Or principally deals with that.
So, my Lord, those are our submissions in response.
Thank you very much, Mr. Fitzgerald. Well, it only remains for the court to thank counsel for their submissions and to thank those who have assisted counsel in preparing the case, including the documents in this case. The court will have to think carefully about what we have heard, and we will produce a judgment in due course. The court will now adjourn.